very difficult to try and, have
Why don't we all take our seats so we can begin?
good test, huh?
If those in the back want to join us, but then close the doors, that'd be great. Well, good morning, all. I think this group could accurately be described as the hardcores. After a week, or in some cases a shorter time, here on Saturday afternoon to conclude this compelling conference that Fionnuala, Ona, and Larry and their colleagues have put together. Before I say anything further, I wanted to introduce Ben Ferenz, a great friend and longtime member of the Society who wanted to say a word about a sad but important event.
Thank you very much, Mr. Chairman. This honor might help.
Can we get
a call from the President of Trinidad and Tobago notifying me that A.N.R. Robinson, who had been the Prime Minister, and he was the one who introduced the idea of an international criminal court to the General Assembly of the United Nations. Without his effort, we wouldn't have had no court. And he dedicated all of his years to supporting it as a good example of how what one human being can do by courage and persistence, and we mourn his loss, and I want it to be remembered.
Thank you, Ben. And if I could give that, who's going to keep, is Lara here? Who's going to do the circulating? You're going to get that for a moment. Okay, so I think Fionnuala and Larry and Ona and their colleagues wisely decided that if we're going to do a conference on the effectiveness of international law, it might be an effective way to approach it to start with Crimea and to end with Syria, and that's what we've done. So you heard, or many of you will have heard, the Crimea panel on Wednesday. We're going to conclude the conference by addressing Syria. We all know the backdrop here. There have been horrific events happening in Syria for years, and yet no real action has been taken to address it. We have the tragedy of thousands, tens of thousands of civilian deaths, deliberate targeting of civilian infrastructure, deliberate use of chemical weapons, an extraordinary refugee crisis, all occasioned by the conflict happening in Syria. We're going to discuss that from the standpoint of law, but I'm sure the discussion will broaden as well. And to do it, we've got four spectacular people. First, Ken Roth, longtime executive director of Human Rights Watch. Human Rights Watch has had researchers in Syria on or off throughout the conflict, based out of their office in Beirut. Mr. Roth is a graduate of Yale and was a former prosecutor in New York. Michael Ignatieff is a professor of the Kennedy School at Harvard. He's a former leader of the Liberal Party of Canada and a former member of the International Commission on Sovereignty and Intervention, which played a seminal role in developing the notion of a responsibility to protect. Vera Galan-Daba is Emeritus Professor of Public International Law at the Graduate Institute in Geneva, and also a visiting professor at University College London and academic member of Doughty Street Chambers. And she's been a visiting fellow at All Souls College, a visiting professor at UC Berkeley, Paris 2, and a host of other universities. She has spent much of her scholarly career studying the United Nations and the UN Charter. And finally, Anna Al-Qassani is a person who's occupied a whole host of senior positions, both in international entities and in national entities. Perhaps most importantly, he has served as the Prime Minister of Jordan and also served on the International Court of Justice, including a stint as vice president. He tells me that he's now leading a relatively low-key life as a farmer and occasional arbitrator. So here's the idea. What we really want to do is have a discussion amongst our colleagues on the podium, but also with you. What I've asked each of the panelists to do is to basically state their position in relatively short form. We're going to have some follow-up questions. What I'd like to do is in the middle of the discussion is turn it over to the floor for a while, and then we'll bring it back up to the podium. So I do want to engage. This is Saturday afternoon. We want basically a discussion of the whole. We're going to start by focusing on the basic legal architecture. And perhaps the basic question we might ask is, how does the current legal framework allow us to attempt to stop the atrocities in Syria? We recognize that there will be a whole host of other considerations, political, military, diplomatic, and those will no doubt intersect, and it will be impossible to talk about the subject without talking about them as well. But in the beginning, I've asked each of our colleagues here to include in their initial presentation what the current legal framework allows us to do, and then to talk more broadly about their basic position. So if I may, Vera, would you like to start?
Thank you very much. I feel I'm being subjected to harsh interrogation techniques here with the lights on. But anyway, my focus, at least in my introductory remarks, is to look at the collective security framework within which the two resolutions, which are really substantive, were adopted. Resolution 2118, which was adopted in September of last year in reaction to the attack, the chemical weapons attack. And the second one is the 2139 resolution adopted last February, which demanded humanitarian access and humanitarian relief. And what I would like to say is that the framework of these resolutions, they go well beyond simply, putting down the conditions for these very rather narrow aspects. I would like to posit the fact that, in fact, they set the framework within which we can examine a whole lot of issues relating to Syria and the limits set by the Security Council on such issues as, is there a hidden trigger? Are weapons to the rebels permissible? Who decides and when for military measures? And so on and so forth, and particularly the question of R2P. But I will be given, I hope, an opportunity to develop this further. What I also want to say is that we have to have a benchmark to, in fact, measure the effectiveness of the Security Council. Now, it is very easy to say that the emasculated collective security system, which was set up after the war, and which is very, very far from the idea of my brother's keeper, is responsible for a whole host of problems and the ineffectiveness of the Security Council, particularly the question of the vetoes. It is easy also to lay at the door of the Russian vetoes the reason why the Security Council has been unable to act. But my point is that the collective security system has not been static. And outside the question of formal reform, it has gone a long way in evolving to meet, in fact, the demands of the international community and the evolution of the international legal system. Let me explain a little bit what I mean by that. The collective security system now reflects the centrality of human rights, and therefore the concept of human security in parallel with state security. It has evolved to link international peace and security and justice in the form of the international criminal jurisdictions, a link which was only made with peaceful settlement of disputes. In fact, justice was kept out of the Security Council's collective enforcement action on the grounds that the Council had to be effective and had no time for justice. Now we see this link be made. We also have had a growing calls for the rule of law as a guiding framework for collective security, and that of the accountability of the Security Council. So the point I want to make is that we need a fresh reading of Article 1.1 of the Charter, in which we can really examine the resolutions that have been adopted. Furthermore, the Council, though a preeminently political body, has claimed a human rights protection function and even an international legislating role, in fact. And it's come to link ethnic cleansing, genocide, and other gross violations of human rights with, in fact, threats to the peace. So, in fact, human rights, which in the Charter was really a secondary consideration, in other words, a longer-term goal for peace, what we used to call peace building, it now forms part of the peace maintenance and the peace enforcement function itself. In other words, it's become component parts of the security fabric. And it is, from this perspective that we have to view the question of how the Security Council approaches the Syrian crisis. So what I will hope really to develop later is the question of the framework which the Security Council lays down and through which we can evaluate what measures can be taken, who can take them, and a whole host of other issues. And I'll stop now.
Thank you, Vera.
Thank you.
Michael?
Thank you. Good to be on this panel with this distinguished group. The one thing I told myself when I was shaving this morning is if you're not a lawyer, don't pretend to be one in this room. That would be a mistake. I am not a lawyer, and so I'm not going to try to be one. The other lawyers up here will do a much better job than I would. I wanted to ask a simple opening question about Syria, which is, what is the best that we can hope for here? What is the end state that we are trying to attain? I mean, thus far with UN Security Council 2118, we've tried to keep chemical weapons out of the fight with some success. That could be classified, I hope, as a success for international law. But there is a question here about what happens if we don't get full compliance with Security Council Resolution 2118. That's another shoe that needs to drop. The second thing we've tried to do with 2139 has been to guarantee humanitarian access, to stop the blockading of civilian populations, stop the denial of aid. Just talk to the ICRC. It is a nightmare trying to do the basic delivery of humanitarian aid here, and so the UN, the international system, has said you must stop using humanitarian aid in these grotesque ways that lead to the starvation of children, the recrudescence of polio, all the things that we've seen. The international community has come in there. So that's the second thing we've tried to do, to try to mitigate the humanitarian catastrophe that's cost 125,000 lives and 2 or 3 million refugees. If you then move beyond that to the third thing, what can we possibly hope for? I guess I would say a stand-in-place ceasefire where the killing stops. That is a reasonable goal. It is not regime change. It is not transition. It is just stand-in-place ceasefire, hold what you have. It is also not partition. Partition comes later if it comes at all. Everybody in this room would start from the presumption that maintaining the territorial integrity of Syria is a goal. Do we want to pick apart the post-Versailles state order? I don't think so. So let's define a de minimis goal here for international policy, which is stop the dying, with a stand-in-place ceasefire in which everybody holds what they've got, including Assad, which means that the United States and Western governments who are saying our strategic goal is to overthrow this regime have got to walk back down the hill and acknowledge the facts on the ground, which are that Assad holds what he holds in the east and the coast roads, and insurgents of various kinds, some of them deeply dangerous, hold other parts. But if your goal is stop the killing, a stand-in-place ceasefire, how would you get there? And that means you have to get parties back to Geneva 3. You have to hand them over to that fantastic international diplomat, Lakhdar Brahimi, wisest old fox in the business. You've got to get them in the room with Lakhdar. How do you do that? At the moment, all the protagonists believe that they can continue to win military advantage. Is there anything we can do to disabuse all the parties that there is a military solution here? Every sentence I give you illustrates just how difficult this is. The only person who can actually enforce a ceasefire on his side is Assad. Getting a ceasefire from the other guys is going to be incredibly difficult. My sense here is that to get Geneva 3, to get a stand-in-place ceasefire, does require collaboration from the two great powers involved, who've just had a standoff on Crimea. Very unlikely to collaborate, but desperately important that they do so that Assad feels some pressure from the Russians to come to Geneva, and the other, whatever we've got on our side, has a similar pressure. It's quite possible that here's where it gets tough. It's quite possible that no purely diplomatic pressure on either side will get Geneva 3 back going with the goal of a stand-in-place ceasefire. Then you're into options which push at the limits of international legality. If the Security Council is deadlocked, is there any possibility of using targeted air power to simply tell Assad clearly, you can't win with barrel bombs? We're not trying to reverse the regime. We're not trying to change the military momentum. We're just saying you can't go on the way you do, so you must come back to Geneva. Most of you, I see some head shaking. Don't talk to me about the use of force. But ask yourself what the goal is here, which is to stop the killing, stop the dying, get a stand-in-place ceasefire where people hold what they hold. Is there any way to do that? My question is, if 2118 isn't enforced, if 2139 is not enforced, if in a year's time savant gatherings like this are still looking at not 125,000 deaths, but you don't like that? How about 250,000 people dead? How about, you don't like 3 million refugees? How about 7 million refugees? Is that okay? This cannot go on. And at some point, I do think that the question of whether there's any possibility of using coercive force with or without the Security Council will inevitably come back, just to attain that simple de minimis goal of stopping the killing now and leaving people in possession of what we've got. I think we have to define what our strategic objectives are here, and that is mine.
Thanks, Michael. Ken?
The premise of this talk was, I think, to what extent should we be contemplating military force, knowing that it's very unlikely that the Security Council would approve it because of the Russian veto, if nothing else. I'm not going to address that immediately. I think that's going to come up in conversation. But I do want to note that the Charter is not the only law in question here. There's also the Geneva Conventions, which have been utterly flouted. Indeed, I think it's safe to say that Assad's war strategy has been one of war crimes. Rather than simply targeting the combatants on the other side, which would be perfectly legitimate, he has chosen to do everything he can to make life miserable for the civilians who happen to live in opposition-held areas. So he has indiscriminately bombed Aleppo with barrel bombs and other things. He has targeted schools, hospitals, and clinics. He's deliberately besieged cities and deprived the entire population of ready access to cross-border humanitarian aid and most cross-line humanitarian aid. The aim is quite simply to make life as miserable as possible in order to turn the population against the rebels, or at least force them to flee, to add to the numbers that Michael just mentioned, in order to undermine the economy and make it more difficult for the rebels to operate in northern Syria. So this is a very ugly, illegal strategy. Now, what has happened about it so far? The response has been fairly pathetic. And this is not, I think it's important to remember, this is not, the only possible response is not military. There have been many options as well that for the most part have not been exercised or have been exercised belatedly. Take condemnation. The UN Security Council didn't condemn any of this in a resolution until February 22nd. They couldn't get their act together. Russia vetoed even condemnations. It had to wait for the UN Human Rights Council and the Commission of Inquiry that it established to even condemn these atrocities. The sanctions that we've been pushing for to try to rein in Assad or force Russia to rein in Assad, we've gotten nowhere with those sanctions until Ukraine. And suddenly, all the sanctions that were politically impossible to save tens of thousands of Syrian civilians from mass murder became possible to protect the territorial integrity of Ukraine. An arms embargo. This is, would be very significant, but there are other interests at stake. Iran, one of the principal suppliers of arms to Assad, there obviously are other negotiations going on, and it's deemed more important to keep the focus on the nuclear question than to spend much time talking about Iran's role in Syria. Similarly, Russia. An obvious way to put pressure on Russia to pressure Assad would be to start a global boycott of Rosoboron export, the principal Russian arms exporter, which is also a principal arms supplier of Assad, but that has simply not been on the table because John Kerry keeps reminding us that Russia has been a partner in peace rather than an accomplice in mass murder. So there are certain quite clear options that have just not been pursued. Even the International Criminal Court, Russia has obviously been threatening veto of this, but the US has been lukewarm about this as well, in part because it was seen as unduly tying John Kerry's hands in the Geneva II negotiations, and in part because of the theoretical possibility that Israel might be prosecuted for its Golan settlements if Syria were referred to the ICC. Very much the tail wagging the dog in terms of what's important here. So there are many things short of military action that might have made a difference. Even if we were to go to the realm of military action, and we'll discuss that at greater length, I'm sure, in the conversation, I would not even consider it for the purpose that Michael's mentioning. I don't think a ceasefire is the goal here. I think if we're going to talk about military intervention, it should be for one purpose only, and that is to stop the slaughter of civilians. I don't terribly care if the combatants keep shooting each other. What I wanted to do is to stop this deliberate targeting of civilians. Now, to date, the Security Council's response to the Syrian tragedy has been poor, shall we say. There was 2118, the chemical resolution, which obviously came only under threat of military action. But before we applaud the Council too much for that, we should recognize that chemical weapons have been responsible for roughly 1% of the civilian deaths in Syria. The conventional killing of civilians has barely been addressed. In fact, was not addressed at all until the February 22nd resolution, which did order an end to barrel bombing and other indiscriminate warfare, and nothing has been done to enforce that. So one of the big questions is, is enforcement on the table now? That same resolution did order Assad to lift the siege, to open the borders to humanitarian assistance. He's barely done that. And so one of the big questions facing the UN is whether, given the lack of willingness under compulsion to allow cross-border operations, will the UN start doing it? Or are they going to still stand on ceremony and wait for Assad to sign on the dotted line, which he's unlikely to do? These are big questions that remain to be seen. Finally, I think that if the Security Council remains an obstacle to the solutions to Syria, we've got to start looking at alternatives to the Security Council. And I don't mean simply ignoring the charter, but we should look at some of the options even under the charter. For example, the UN General Assembly theoretically could establish a tribunal under some concept of universal jurisdiction. It wouldn't have the same coercive power of a Security Council established tribunal or a referral to the ICC, but I see no legal obstacle to a GA-created ad hoc tribunal. Theoretically, we could be talking about uniting for peace with respect to military action as well. And I think we also have to look at some of the options that France, I suppose, has been most identified with, of generating pressure on the permanent members of the Security Council not to use their veto in situations of mass atrocities. There are even some sort of procedural hints in the charter about how this might be done. I think most people don't recognize that there actually is a requirement for Chapter 6 matters for a party to a dispute to abstain from a vote. Why are we not applying that to Russia, very much a party to the dispute, with respect to possible Chapter 6 action on Syria? So there are creative things that can be done that would move past the roadblock. Obviously, the other permanent members don't like these options of moving past the council, because they like the prerogatives of the veto too. But we have to start asking, are these prerogatives as important as the many lives that are being lost in Syria today? So much more for discussion. I'll stop there.
Thank you, Ken. On, please.
Thank you. At the outset, I wish to start by saying how delighted I am to be here, and therefore how grateful for the kind invitation to participate in this distinguished panel on such a topical and important subject, one that touches everyone's sensibilities and deeply held convictions. I should say also that having been the Prime Minister of Jordan while the crisis, so to describe them, in Syria were unfolding, having had to deal with the ramifications of those crises, the opinions I express today are mine and do not represent the official position of Jordan. In fact, I do not know what the official position of Jordan. Let me go immediately to the heart of the matter. I would start by briefly recalling some pertinent elements of the background to the present situation in Syria. It is reliably reported that shortly before his death, Hafiz Assad, Syria's longtime ruler and dictator, said to his son Bashar, and I quote, "I have prepared the country for you for the next 20 years," unquote. This was no idle boast, as those who have predicted the swift fall of Bashar or his regime learned to their cost. Hafiz had stifled all opposition, suppressed with a disproportionality bordering on annihilation the main source of opposition to his rule, the Muslim Brotherhood, in the infamous massacre at Hama in 1982. He created a sectarian army, created also no less than 50 intelligence services separately reporting to him, implemented a policy of divide and rule. In sum, he had largely succeeded in breaking the spirit of an old and proud people, and any prospect of change must have looked well nigh impossible to them. If it were to come at all, it had to come from an external source bigger than Assad's regime. Well, the regime failed to provide. What the regime failed to provide for, however, was the prospect of dealing with peaceful demonstrations. One detects an ease in dealing with the first few months of the peaceful protests when the demonstrations were spreading spontaneously throughout the country. Although I have to pause here and nuance the reference to spontaneity, recalling that there were already reports of the smuggling of arms into Syria and of activities to cause the masses to rise up against their government in what was openly referred to as an attempt at regime change. This, of course, was not just confined to Syria. It was part of a pattern in what is euphemistically referred to as the Arab Spring. And, of course, most recently, the same thing happened in the Ukraine. But be that as it may, the progressive militarization by outside forces, both Arab and Western, of what had essentially been the implosion of a long-suffering people, relieved the system of its hesitations and its killing machine started again operating on the old system, as it had done in the past. This militarization also caused the simple revolution to metamorphose into a number of interrelated conflicts. First, a proxy war between, on the one hand, Iran, and on the other, a disparate group of states, the Gulf states, or most of them, plus Israel and the United States. And secondly, into a sectarian war among Sunnis and Shiites. And thirdly, as what is on the verge becoming a new mini-Cold War. In this complex series of Greek tragedies, the facts surrounding the commission of heinous crimes are in question. The very facts of themselves are in question. The establishment of responsibility, therefore, becomes even more difficult. The most that we can say now is that both the government and the various rebel groups and their supporters bear responsibility. In the case of the latter, this responsibility is similar to that of the United States for the actions of what was referred to as the unilaterally controlled Latino assets in the Nicaragua case. Well, the government's responsibility is, of course, direct, provided it can be established. At any rate, it would not be rewarding to delve more into questions of state responsibility or even of personal criminal responsibility, for their implementation is not assured at this stage due to the lack of effectiveness of international law. It would be recalled that in 1982, the Assad regime committed one of the worst massacres in modern history in the city of Hama. Apparently, when the present crisis began, the United Nations Secretariat searched its files to find any international reaction to the 1982 massacre, to use it as a precedent, but found none. In fact, there was one reaction to that massacre, and it emanated from Jordan, and it was in the Human Rights Council Commission in Geneva. By pure coincidence, I was personally involved in that episode. And I beg you to permit me to recount it very briefly because of the morale that can be drawn from it. As news of the massacre in Hama and also in the Palmyra prison were reaching a shocked public conscience, the Prime Minister of Jordan asked me to prepare a suggestion on what could be done in response to those news. I was at the time acting legal advisor in the Ministry of Foreign Affairs. My suggestion was that Jordan, which was a member at the time of the UN Human Rights Commission, should introduce a resolution not condemning Syria, not passing judgment, simply asking for a commission of inquiry. The draft resolution was duly introduced, but in the last day of the session, there was a motion to take no action. This motion was made by the ambassador of a Western power with a permanent seat on the Security Council, and thus was killed the only attempt to react within the institutions of international law to that massacre. So much for the effectiveness of human rights and international law. It became clear to me that human rights were always second or perhaps third to geopolitical or economic considerations. When Hafiz said to his son Bashar, "I prepared the country for you for the next 20 years, it was not just the domestic arrangements and measures talked about earlier. It was also the international alignments of Syria that provided protection to the regime, and they still continue to do so. The lack of reaction to the 1982 massacre also serves to illustrate that the lack of effectiveness of international law is not an isolated incident, an exception to the rule, so to speak. It is the rule. A cursory look at the problems of the region, whether we are speaking of the question of Palestine or the war on Iraq or on terror, shows a discernible pattern, and it is one of decay of international law. The abuse of the right of veto, unilateral actions contrary to the Charter presented as collective action, the blatant violation of Jus Cogens obligations, such as the prohibition of torture, and others, etc., etc. It's a long litany and too well known for me to need to repeat. All in all, it is a black picture and has been so for some time. But this picture is, in fact, the very context in which the present strife in Syria fits perfectly. Let me say a few words about the
Perhaps we could give everybody a chance to respond to your comments, then I'll come back to you and you can elaborate on the comments you're about to make. Would that be okay?
Will you want me to stop now or to stop?
No, well, we want to make sure there's a full chance to dialogue. So if you wanted to finish up your remarks within the next couple of minutes, and then we want to make sure that we have a chance for you to respond to your colleagues and them to respond to you.
I just have two more pages.
Please.
Okay. Let me say a few words about the question of intervention in Syria. Direct military action without charter authorization was contemplated, but luckily averted. There are those who now wish to revive that option in the best traditions of saber rattling, especially after Ukraine, and perhaps in response to Russia's annexation, or as it has most recently been called, reintegration of the Crimea. I leave the incalculable questions of geographic consideration to the specialist. But as a lawyer, my position is one of extreme suspicion and weariness of calls for intervention, even when the local sovereign is a monster. At least in the Middle East, intervention under the guise of humanitarian intervention has always been used to further hidden economic and/or strategic agendas, and has been to the detriment of the affected country. The 1860 intervention of France and Great Britain in the Lebanon is a case in point. Moreover, if the intervention were exceptionally permissible to avert such an impending disaster, such as the intervention to save the population of Benghazi, though not, of course, the widening scope of that intervention in Libya, the question remains that after 3 years of strife, about 150,000 people killed and millions of refugees and internally displaced persons, any intervention would serve no purpose and would only exacerbate an already tragic situation. What we have in Syria now is partial intervention, which is the worst of all possible worlds. The Syrian people, having been encouraged to rise against their oppressors by their Western and Arab backers, have now been abandoned. From the beginning, there was, according to many observers, no serious intention of changing the Syrian regime, but only to weaken it through attrition. The objectives from the beginning seem to have been twofold. First, to compel Assad to give up his chemical weapons arsenal, and secondly, to make Syria a magnet for jihadi groups as fodder for the strategy of weakening the regime and its supporters in the Hezbollah. Vera has already mentioned in her abstract that she considers the concept of responsibility to protect a hollow and unnecessary one, and I share that view. Apart from other considerations, it will never be invoked against powerful states, and I think the case of the Ukraine is one in point. I believe that regional actors should have assumed and should have been given by the Security Council greater powers under Chapter 8 of the Charter. I believe that the only hope of finding a negotiated solution to the problem, which is the only sane option, would be to bring in both Turkey and Iran as major stakeholders, and Saudi Arabia, of course. Previous attempts to affect such a scenario have been have been frustrated by outside powers. But now with the military balance shifting in favor of the regime, this scenario is much better than the continuation of a futile and catastrophic conflict. In saying this, I am not unaware that diplomacy and not international law will be the basis of any solution. And of course, any outcome will be non-principal solutions, rather those based on international law. It may even involve immunity to those who have committed so many crimes. But this is the price that must be paid for the total ineffectiveness of international law in the Syria crisis. In sum, while I am gratified, as we all are, that in many areas the effectiveness of international law, the theme of our meeting, is good, as for example, greater resort to the International Court of Justice and compliance with its decisions, confirms in areas relating to international peace and security, the crisis in Syria being a prime example, it is latent opportunism and imperial hubris rather than law that seems to be the order of the day. Thank you very much.
Thanks for those remarks. Vera, I'm hoping that you will follow up, particularly given that Ken and Michael both mentioned the recent resolutions, 2139 and 2118, and just elaborate briefly on your view of collective security, perhaps place those in that context, place those resolutions in that context.
Thank you very much. Yes, I want to follow up on Kenneth Roth's military option, in fact, by looking at these resolutions and, in fact, what they lay down. Now, it's clear that the resolutions do not authorize any use of force. It is clear that there is no hidden trigger. We're not back to 1441 and the weapons of mass disappearance. So the only option would have to be to work outside the charter. I agree with him, and I'll come back to that option and what I think of it, unilateral military force. But I want to agree with you that the resolutions are very narrow. It's undoubted that chemical weapons are outlawed while barrel bombs and whatever are killing thousands. But nevertheless, these resolutions do lay down some principles within which diplomacy should take place. I think if we don't accept that there are certain frameworks, the military option really takes us back to, it's not progressive development, it takes us back to a very regressive situation before the charter, where it's the whole unraveling, in fact, of the attempt. We must think of the purpose for which Article 2.4 was put into the charter. There's also an obligation to settle disputes peacefully and so on. But let me go back to what kinds of principles. Number one, the resolutions address both parties. Both parties are terrible violators of humanitarian law and so on. Interestingly, the resolution 2139 talks about terrorism and calls on the Syrian authorities, that surprised me a little bit, on the Syrian authorities and on all the other organizations, in other words, to commit to combating and defeating organizations and individuals which commit acts of terrorism. And that's very interesting because, of course, Assad has used this as an excuse. Everyone else is a terrorist, and the Council does endorse that. So you can, you have to ask yourself the question, why? But it is a recognition that everyone in there should be targeted. And if you go to the military option, then you should target all the 39 or however many factions there are. What is also interesting is that the Security Council insists that the provision of humanitarian aid should be done on the basis of what in Nicaragua had been the ICRC principles to alleviate human suffering, impartiality, neutrality, in accordance with the guiding principles of the United Nations itself for emergency situations. and that calls on not to intervene without the consent of the state concerned and so on. Why is that resolution, these guiding principles reintegrated? It's a reaffirmation of the type of humanitarian assistance that should take place. Right, what about the unilateral option? If we don't get an authorization from the Security Council, right, one of the bases that I've heard throughout this conference, one of the running themes has been R2P. And I have said that I consider this a very unnecessary concept. Unnecessary because we know that R2P originally began as a kind of fig leaf for humanitarian intervention, but quickly was constrained by UN reports and so on to take, it was constrained in the framework of Security Council authorizations. But the Security Council does not require such a concept. Its legal basis is to be found in the Charter. It has already shown that it can act in situations of human rights and humanitarian law violations. So I don't think, and besides the duty to protect, which I think underlies the R2P concept, it's impossible within a Security Council context where, in fact, the procedural obstacles are very evident. The Council does not act automatically. It does not respond with any automaticity. So that's, yeah.
Can you just conclude that point? Because I want to ask Michael to respond directly to your comments on this.
Right.
So if you could just conclude.
Sure. Well, I was going to go on to something else. What other options
let me,
are?
if I may,
so I'll stop here.
With your indulgence, stop you there. Michael, Vera's just characterized responsibility to protect. What I wanted to ask you was, and I know you've disavowed any status as a lawyer as you sit up here, but since you developed or had a large part in developing the concept, what role did you think it would play when you were developing it, and what role do you think it now plays?
Well, it seems to me that it's been slightly mischaracterized. The report of which I was a drafter and signatory was extremely clear that the use of force should always proceed under UN Security Council authorization. We're clear. We say as a statement that in conscience-shocking situations, in other words, where legitimacy and legality part company, states may act. We didn't approve or disapprove. We simply said that's just a fact of international relations. The question that's being asked is whether it adds value to this discussion. It seems to me it does, in the sense that it defined in some precise terms the conscience-shocking situations that, it seems to me, demand Security Council action, A, and B, it formalized what I think what you said, which is that sovereignty has changed since 1945, and it's not inviolable and absolute, and it implies some obligation, some responsibility to observe basic human rights. We made the point, however, that in an international system, this is a point made by some distinguished lawyers in this room, including Brad Roth, sovereignty is designed for a pluralist world, a world in which we do not agree about justice, in fact, in which we disagree about justice. And disagree about what human rights means. The point about R2P was to work in a pluralist world in which there are limits to pluralism. The limits to pluralism is mass massacre, genocide, ethnic cleansing, and we simply restated and tried to put in formal terms what seemed to me emerging ideas about responsibility in the international arena. If distinguished lawyers don't find it useful, fine, but and I would not claim that it's an emerging principle of international law. I wouldn't go that far. It seems to me to have defined and shaped the debate about international intervention in a positive way since 2001 when it was drafted, and I think it's got a long future ahead of it. But I would never tell you it's jus cogens. I would never tell you it's customary international law. It seems to me an extremely important heuristic for a pluralist world.
Ken, a comment?
Well, on R2P, I mean, I think it has two broad forms of significance. I mean, one which we tend to slide over very quickly is that it speaks foremost to the national government. It says, you have a responsibility to protect your people, that's an essential attribute of sovereignty, and that if you fail in that responsibility, there will be consequences, and then there are other various options laid out. So the idea that sovereignty is not sacrosanct, but comes with responsibilities toward the residents and citizens of that country is a very important one. The second then speaks to the international community. And Michael's absolutely right that the drafters of the R2P doctrine were very careful to give proper obeisance to the Security Council. But in fact, the real significance of R2P is that it's mostly understood as not necessarily requiring Security Council action. I mean, that's the popular understanding of it, even though the technical legal understanding is absolutely as Michael said. Now, Syria has been a challenge for R2P, because even though everybody understands that the mass atrocities in Syria do trigger R2P, there have been big debates about what the appropriate response is. And even with respect to military action, many people ask, does the proposed military action pass the test of being likely to make things better rather than worse? And there's genuine debate on that topic among people who very much want to see an end to the atrocities. But I'm not one who thinks that Syria spells the demise of the R2P doctrine. In fact, if you just look at recent use of the doctrine, I mean, just in the last year with Central African Republic and South Sudan, it was very much acted upon. We don't have these big debates about whether, at the time that it was the Central African Republican government, whether the Seleka was consenting to the French intervention or not. Nobody cared. There was mass atrocities, and the French went in, the African Union bolstered its peacekeeping force, the UN has now sent in there's authorized peacekeepers. So again, we let's not get too caught up in Syria here. And we've seen, similar in recent years, use of the R2P doctrine, I think in Cote d'Ivoire, again with a combination of a French and UN peacekeeper intervention. You saw it in Kofi Annan's work in Kenya without military intervention, with very active international involvement to end the ethnic killing there. So it is important as a heuristic advice to urge people to act, but there also is a shift, at least a popular shift, in the understanding about what the world should do. And I, for one, don't reify the UN Charter. That's an important form of law. I understand that that's structural law, it's intergovernmental law, but there are other laws involved here, the Geneva Conventions, common law against crimes against humanity, which are flouted in R2P situations. And you then end up having to ask, which law is more important? The law protecting people from mass slaughter, or the law structuring relations among states? And this is, a good debate, but the answer isn't obvious. You can't just say, oh, the Charter wins always. Maybe not. And I think that that's, what the R2P doctrine has forced us to debate.
Vera, one quick response to those points on R2P?
Yeah.
Or response to
That's the problem with sound bites. I didn't have a chance to nuance what I was saying. In fact, I was only talking about R2P as an unnecessary concept where security, the legal basis of military action was concerned. I agree with you. There is a preventive aspect, and there are all kinds. And the only time it was used in Libya, everybody said this is R2P. But in fact, if you look at the Libya Resolution 1973, the emphasis is very much on the responsibility of Libya to protect its own population. And we have the same echo in the Syrian resolutions that I was talking about. So I'm not saying it is, a concept. Of course, it reflects also what I've been saying about the evolution of the collective security system, where human protection or protection of human rights is right at the core now of security, of international security. So just don't misunderstand me.
Thank you for that. On quick response to, you mentioned responsibility to
My position is quite similar to Vera. I mean, with regard to the non-military aspects of the concept of the responsibility to protect, I am at best only half convinced of the arguments. I don't think it is harmful. Of course, with regard to the to its use as the basis of military action, I think it is simply it's impossible for me to accept the thing. Maybe I'm too much of the old school and formal law to advance with the times.
Well, let me ask him, maybe this is initially directed to you, Ken. Let's pose the hard question, and particularly for a human rights lawyer, I think an important pillar of the human rights movement has obviously been human rights law, has been law. It's been part of a major vehicle by which we've advanced the human rights agenda. If I may pose what doesn't seem to me to be an extraordinary hypothetical to test whether or not we are moving toward a freestanding norm of responsibility to protect, which is imagine Syria. Imagine we had irrefutable evidence of successive instances of the use of chemical weapons, and imagine that Russia used its veto to preclude military action, and assume further, obviously a big step, that a state was prepared to go in and use its blood and treasure to stop. Do we have to fall back and say that's illegal but legitimate? Do we use Tom Frank's notion of mitigation or excuse? What is the status of that action? Or should we be open to the notion that given the very small prospect of security reform and the constant instances of powers on the Security Council using the veto to advance what seemed to the international community or the broader international community narrow interests, should we be open to the development of the responsibility to protect as an independent norm that stands beside the Charter and perhaps sits on some of the other legal bases that you've identified?
Well, I mean, it is a norm. I mean, does it have the status of law? Not yet. It is, I mean, you don't even have to go to the chemical weapon example. I just take, contemporary reality in Syria, where, you have mass slaughter taking place, 5,000 deaths a month, let's say. I think the way to look at, what is the option that's on the table, and this is not something that Human Rights Watch, my organization, has endorsed, but the option that people talk about is actually not the way Michael portrayed it. It's not, using military force to force a ceasefire or to force Geneva III negotiations, because frankly, it's really hard to calculate that. And it's very easy for those kinds of calculations to go wrong. Rather, I think what's been on the table is, are there military steps that could be taken that would undermine the means that Assad has been using to slaughter many civilians? And here, I mean, I actually disagree with you. I mean, yes, there are atrocities on both sides, but the vast majority are at the hands of the Syrian government. You don't have to, over-complexize the issue by saying you got to attack 39 different forces. No, the bulk of the killing at this stage that could be remedied are the planes and the helicopters being used by the Syrian government to drop barrel bombs, to indiscriminately fire on civilian neighborhoods. And that's why, frankly, the response to the chemical weapon use, the option that was being very seriously looked at that point was bombing the airfields and trying to destroy some portion of the Syrian Air Force. Not that that would end the war or necessarily even force a negotiation in Geneva, but it would just undermine the means that were being used to slaughter so many civilians. So I think that's the issue that's on the table. And if that step were taken, I think what we want to look at is what is the way to maximize its legitimacy and what is the way to minimize its being used inappropriately as a precedent. Because obviously, Putin cites the severe persecution of those poor persecuted Russians in Crimea, to justify his actions there. Bush did the same thing in Iraq, where, after the weapons of mass disappearance were not discovered, he then cited human rights as the reason for having acted. So, the fact that people do misuse the doctrine, I don't think is a reason not to have the doctrine. It's a reason to sort of push, to condemn this dishonest use of it. But you do nonetheless want to avoid, as much as possible, unilateral military action. And therefore, I think that the broader body that you can get to endorse R2P military action, the better. That's why I'm actually interested in reviving the UN General Assembly Uniting for Peace concept and merging that with R2P, because there you have, a very broad body that would have quite a bit of legitimacy, even though it's, not the same legality as Security Council action. You could probably find similar things were, the League for Arab States to act, or some relevant regional body. But those, I think, are the issues much more pragmatic than the grand concept of is this a legal norm now or not, which I don't think we can really answer and is probably not going to get there for a long, long time anyhow.
Michael, and then Vera, and then on concretely, what do we do? Whether we use the prospect of chemical weapons or the atrocities that are clearly happening, what do we do?
I would want to emphasize what Ken just said. If we see this as a conflict between strict legality and moral legitimacy, between legality and moral necessity, we miss the fact that we're also talking about the defense of a whole set of other international laws. Geneva 1, 2, 3, 4, crimes against humanity. And sometimes those who defend Charter 2.4 think the only way to defend international law is through the defense of the Charter rules. And that's why I think that's why we're talking about this. This is why this is painful and difficult. I think the differences between us about when you might use military force are small. I think it is to stop mass killing. The preponderance of mass killing is by the regime. My point is that you must never use military force unless it is connected to a political and diplomatic strategy, since there is no military solution here, and the West should never, or any ally should never get into a military strategy that does not have a diplomatic and political route somewhere that gets us back to, this is where I'm talking about ceasefires, and I'm making the strategic goals suboptimal, that is, stand in place, simply because we have tried more elaborate strategic goals. Assad must go, and I think we're, in realistic terms, that's not going to happen, but it is possible, I think, to get the killing to stop, and then you take it one painful day at a time. Every day in which people are not dying is a day in which they discover that it's good to be alive and better than killing. You create indigenous desire for the killing to stay stopped, and you take it from there one step at a time. Look, I don't think there are risks all across the board when you use force, but I just think what I look at is a world in which we sit and watch this thing for another 3 or 4 years. And it's not just a humanitarian catastrophe, it is a strategic catastrophe for Lebanon, for Jordan, for Turkey, for everybody, for Iraq, for the Kurds. And that geostrategic implication needs to be put here.
Before I turn to Vera and On, I'd like to alert you folks, those with questions, in a couple of minutes, I'm going to ask people to come to the microphone. If you would, I'm happy to have comments as well as questions, but given the time constraints and given the number of people in the room and how much more we want to hear from these four, I'd be grateful if you'd formulate very sharp comments or very precise questions. And do we have where's the microphone? Okay, so if folks could start lining up, I want to ask Vera to respond to the question, then On. We have these continuing atrocities. There's no question that's happening. They're going on. What do we do?
Okay. Just very briefly to respond to what has been said. I think it's too easy to put sovereignty on the one hand and human rights on the other, and to say we have come a long way and therefore sovereignty has to give way to human rights. I think that's a false dichotomy. We are all agreed that human rights, that sovereignty is not a bar to human rights. I think the real question is who decides to do what, and what measures do we use to do what. We're not arguing that this would be an intervention in sovereignty, and I think that's the real debate. So also the question, I take the Kosovo crisis, for example. India got up in the Security Council and said, everyone says that there is an ex post facto agreement or legitimization of the Kosovo intervention. But when China, Russia, and India are all against this, we're 3/4 of humanity. Yeah? And I think that's the importance of the United Nations, is that it does represent all the states and their views. And if there isn't consensus at one point, then it is not representative of all of the votes. What also bothers me is that unilateralism now purports to speak in the name of the international community. It's not the good old, humanitarian intervention. And who purports to speak in the name of the international community? And there is a conflation now, which is very worrying, the privatization of military force and unilateral action gets mixed up because the collective, is pushed by the unilateral, and the unilateral purports to speak in terms of the collective. And I think that's a rather insidious thing. So what do we do? I'm always worried when we say, we don't know what to do, therefore let's have military force. There are a number of options. They may not, they're slow, they may not succeed. I think that one of the most important things is to have an arms embargo, to stop intervention in Syria. And I think there may be different ways of doing it. There are diplomatic ways of doing it. There are economic sanctions. There are all kinds of things that one can impose. Other option, as you've said, is the ICC, which I agree with. There was a letter signed by, Switzerland pushed a letter signed by, 56 states urging, a referral to the ICC. And then most important, and this comes out in those resolutions, I don't think we should discount them as being narrow. Of course they're narrow, but I think we should look into them to see what are the guiding principles. And one of them is the insistence on peaceful resolution of the dispute and the calling of a conference. We know the conference has failed, but that's not an end of it. The reason why we have to ask ourselves the question, why did the conferences fail? Were there too many preconditions? When you come into, you invite Assad and you say the purpose of the whole conference, as Kerry said, is to get rid of Assad. That's not a good start to getting Assad to come to the conference.
So concretely, we know that there are massive atrocities happening. What do we do to stop them?
Very briefly, what we should not do is to resort to military force. And I say this not purely from the point of view of formal legal arguments, but from, I think, an understanding of the times that we live in. There was an Egyptian jurist in the 15th century, Sharani, who once said, the wisest of people are those who can best interpret their times. I think the time for this easy resort to military force is over, and there are incalculable risks to international war, international peace and security if we don't rein in these wishes, so to speak. What we can do, of course, I also agree with what Vera has said. Of course, we shouldn't sit idle and see this horrendous killing go on. I think a big role should be given to the regional players. And for the life of me, I cannot see why in Geneva too, Iran, for example, was excluded. I mean, it is a stakeholder. It is the party that can bring pressure to bear on Assad's regime. And whether we like Iran or don't like Iran, we are not in the business of love and hate. I think it should have been brought in. I think if there were to be Iranian, Turkish, and probably Saudi Arabian intervention with the aim of achieving the minimum, which is to stop the killing, and then we will take it on from there. I think that is really the only sane option.
Okay, what we're going to do is we're going to take 4 questions, 2 each from each side. And as I say, since we have limited time, if you could be very precise, and then I'm going to ask any of the of my colleagues on the podium here, on the dais, if they'd like to respond. Please.
My name is Valerie Epps. I teach at Suffolk University Law School in Boston. One very brief comment. First, I'd like to weigh in on the side of the R2P skeptics. While recognizing its persuasive power, it is essentially a rule designed for the powerful. And the powerful don't have any moral supremacy over the less powerful. So I want to weigh in on the side of the R2P skeptics. Secondly, I'd like to ask Mr. Roth whether he'd be willing to reconsider something that he said while recognizing his wonderful work in human rights. He said, well, Professor Ignatieff, I can never say your name, Ignatieff said he wanted to get to peace. And then Mr. Roth said, oh, well, I don't really want to get to peace. I don't care if the military keep shooting at each other. What I want is I want to protect civilians. I'd ask you to reconsider that in light of the fact that most, indeed almost all modern wars result in more civilians being killed and injured than the military. So the fact of the matter is, particularly with internal armed conflict, you cannot actually have an internal armed conflict without killing more civilians than you do military. So I wonder if you'd be willing to reconsider that statement about just let the military fight each other.
Thank you. A question from here.
Thank you. My name is Tyler Thompson with the Public International Law and Policy Group. My question is also for Mr. Roth. You mentioned the Uniting for Peace resolution. And as far as I know, Uniting for Peace resolutions are non-binding and reserved for when the Security Council has not or is not able to act. And for better or for worse, it seems that the Security Council has acted with 2118 and 2139. My question is, if Assad is not willing to comply with either of those resolutions and the P5 is not willing to enforce them, then what about a Uniting for Peace resolution or other General Assembly action would draw compliance or enforcement? Or is Uniting for Peace just another yet untapped source to show international displeasure with the situation in Syria? Thanks.
Question from this side.
Thank you to all the panelists. I have been a bit surprised that, speaking of responsibility to protect, none of them have mentioned the main document in which such a notion has been incorporated into the, let's say, international canon. I'm referring basically to the declaration of the 2005 summit at the United Nations. There, all the member states unanimously incorporated that idea into the UN instruments, but putting it in a multilateral context. Of course, the Canada report, of which Mr. Ignatieff was one of the authors, was intellectually a very important contribution, but it is not Moses' law. And on the contrary, an instrument adopted by almost 200 states of the United Nations carries much more weight. And that declaration insists on having a multilateral context provided by the General Assembly, by the Security Council, by the Secretary General. And this is what we have to build on. The question is how to build on those resolutions that have been mentioned in order to push the parties to come to Geneva and to settle really the problem with the support of the big powers and of the regional powers as well. I forgot to say, I am a former permanent representative of Spain to the United Nations and former negotiator and signatory of the Rome Statute of the ICC. So I cover both sides. Thank you.
Thank you. And then one more, and then we'll let the panelists respond.
Jean Woods from Loyola University School of Law. I have 3 quick questions. One is the U.S. supply of arms to the Syrian rebels illegal under Nicaragua? Second, could you compare the Security Council response to Syria to its response to the U.S. war on terror and the invasion of Iraq? And third, it struck me that all of the states in which R2P is being deployed are from Africa. Central African Republic, South Sudan, Cote d'Ivoire, Kenya, Libya. Is this a coincidence? Is this being coordinated with the AU? I know they do have an R2P in their charter. Thank you.
Thanks. Maybe, Kenneth, we'll start with you since a couple were directed at you, but then ask each of the panelists to respond to any points that they want to, that they feel compelling. Ken, to start.
All right. Well, there are a few questions on R2P. And I mean, at a certain level, when you say R2P is only for the powerful, I mean, it's a bit tautological in the sense that, yes, it's going to be only, powerful militaries that can actually exercise the military part of R2P. But I think we have to recognize that R2P is actually for the weak. R2P is for the people who are getting slaughtered. Okay, and the question is, are you going to do nothing for the people who are being slaughtered, or are you going to try to do something for the people who are slaughtered? And then if you're going to try to do something, you look around and see who can do it. Sometimes, I mean, this is pre-R2P, but sometimes it's Tanzania removing Idi Amin, is the Vietnamese removing the Khmer Rouge. These are not superpowers. They were just the ones who were willing to act, and with all kinds of imperfections. But it was better that they acted than they didn't. In contemporary times, again, it's I don't think we're terribly particular about who stops the mass slaughter as long as it stops. And so I tend to start from the perspective of the victims. It is, the formal R2P doctrine, I guess, since it's been articulated, has tended to be only in Africa. But you don't have to go back too far. Take East Timor, which is effectively an R2P situation, where Indonesia was coerced to consent to the Australian deployment there. So there are lots of historical analogs where effectively R2P was used outside of Africa. In terms of my comment about I don't care about the combatants shooting at each other. I mean, maybe I was being a little bit too too facile there, but my concern is that John Kerry's approach to Geneva II was basically we will get a grand political agreement and that'll stop the killing. And I just think that is all power to him, but I don't want to put all my eggs in that basket because I don't have a lot of faith in there being a grand political solution. I think that it's very likely that the best we're going to get is Lebanon or Bosnia, a balkanized territory with various powers controlling different parts of it without any political solution. And so my aim is to find a way to stop the killing of civilians while this forever process of finding a political solution proceeds. And I think the two can be severable to some extent. They obviously are related, but there are certain techniques such as the barrel bombing that could be stopped with appropriate pressure. And that would make a big difference for the Syrian people who are living with these bombs that can destroy a dozen houses on a try. There was an article in the LA Times, I think it was yesterday, the day before, where the people of Aleppo have become indifferent to the rockets because they just kill a few people. And so they kind of sleep through the rocket attacks because it's the barrel bombs that they're worried about. That just shows what we've stooped to. So there are steps that can be taken short of the grand political solution that make a big difference. With respect to uniting for peace, I mean, it's a shorthand, and I'm not even sure that that's the right term, because traditionally it's been used really to refer only to the General Assembly authorizing military force. I mean it's somewhat more broadly than that, and if we want to use a different term, that's fine. But I think that when the Security Council is not pursuing its responsibilities to address mass atrocities, we need to look to the General Assembly to do some things that traditionally we've looked only to the Security Council to do. The preference by far would be to go with the French proposal that's been on the table for a while, where there should be no veto in mass atrocity situations. I think that's a very interesting proposal, but the P5 are not jumping on board. So, if we're stuck with the status quo, we should look to the General Assembly. I think I'm particularly interested in looking to it to set up a tribunal, as I mentioned earlier, which there's no reason why you can't. It wouldn't have the coercive power of a Security Council established tribunal, but who cares? Because it's not like anybody's going to invade Syria to pick up suspects. So ultimately you're going to have to find some way to get suspects down the road anyhow. But the tribunal could be very important as a statement of justice, as a deterrent. It'd be useful to do, and I'd like to see the General Assembly acting. If we're worried about R2P being too liberally used to justify military action, we should be looking for things, if we're not going to settle for the purely legalistic, only the Security Council can approve this, and I don't subscribe to that theory, then we should look for other ways where military action can be used under R2P, but not too easily. And one route would be to look to the General Assembly. Another route would be to look to regional bodies. So that's my point in bringing up the General Assembly there.
We'll start with Owen. Are there any of the points you'd like to respond to, and then we'll work back around to through Vera and Michael.
Well, with respect to the question of whether the United States is supplying weapons to the rebels, of course, I am not in a position to affirm that or deny it, but I think the question which is more often asked in the Middle East, at least, is whether the United States is supplying enough weapons to the rebels as to make a difference. With regard to the question of the uniting for peace, I can only recall a saying to the effect that the dignity of truth is lost with too many affirmations. I think the General Assembly has been overused in the past with regard to other conflicts and attempts to get results when Security Council has not been able to find the necessary unanimity. I wouldn't really put too much, I wouldn't place too much hopes on the action of the General Assembly. I'll be very surprised, again, speaking not only from a purely formal point of view, but from our reading of the world. I think that there was a window of opportunity after the collapse of the Soviet Union. And I think, unfortunately, it was squandered in senseless wars. Now, with a resurgent Russia, I don't think the game is the same one, and we have to take that always into account in making our calculations.
Vera?
First of all, I want to take the comment that was made concerning the fact of using military force and therefore more civilian casualties. And in fact, if you look at Kosovo, depleted uranium, bombardment of refugee convoys, Chinese embassy, and so on and so forth. And I do agree that the consequences are unpredictable. You never know where you're going to end up if you do use military force. There's no such thing as a clean strike, clean surgical strike. As far as the question of peace, of a settlement through conferences, I think that one of the mistakes was, in fact, not to have all the regional protagonists. I think Iran should have been there. After all, it's an important player, whether we like it or not. It's interesting that Russia and the United States, when they agree, they produced a framework for the destruction of chemical weapons. There has to be some diplomatic move, and there I'm wondering how Ukraine is going to affect this. Will there be a parting of ways, and even further parting of ways between Russia and the West? Or on the contrary, can one use Syria versus Crimea to, in fact, ensure that there will be some collaboration? And I think that is extremely important. As far as the General Assembly is concerned, I've always been pushing for the General Assembly to play a far more effective role in world affairs. The ICJ in the Wall case, in fact, bolstered the powers of the Assembly, or supported the Uniting for Peace resolution, and in fact confirmed that the General Assembly plays a residual role in peace and security, and it can do quite a lot in its recommendations, whether of sanctions or other measures. The problem is that the General Assembly has not been assuming this role. After the end of the Cold War, we've had a very subservient General Assembly. One thing that is, of course, not sufficiently pushed by the General Assembly is the fact that the Security Council has to report to it, has to make special reports on the way it is conducting or responding to crises. And I think that is an important, it played a somewhat small role in that during the sanctions situation. Finally, I think the responsibility definitely of the permanent members of the Security Council should be insisted upon. There is a growing call, as I said before, in talking about the evolution of the collective security system, there's a growing call for accountability of the Council, but also for the concurrent responsibility of member states with the actions of the Security Council. So on the one hand, you have that call. On the other hand, in terms of weapons supply, you have, on the contrary, if you want to talk about responsibility issues, Austria, for example, in a recent declaration, has stated quite bluntly that supplying weapons would, of course, implicate the possibility of complicity with the atrocities perpetrated by the rebel movements. And Article 16 of the State Responsibility Articles has been elaborated on very seriously. It's now really referred to. So you have responsibility in all aspects. You have the responsibility of the permanent members for what the Security Council does, but you also have their own responsibility and the possibility of complicity.
Michael?
This conference meets at a time in which I think the rules for the international use of force and the management of international conflict are in more difficulty than we imagined they would be at the end of the Cold War. Crimea on the one hand is one bookend, Syria is on another. Unilateral uses of force by one great power, total inaction and Security Council blockage in relation to another conflict which is costing 150,000 lives. So international law is having a very tough go. There isn't a person in the room. This is the trade union of the international law movement, and your trade union wants to strengthen international law, and I think everybody on this panel wants to strengthen international law, and it's significant that there's quite a substantial and enduring difference about how to do that, and that seems to me actually inherent to the problem. I don't think we're going to get to yes here, and the crucial point is always about when and whether and in what circumstances you can use the use of force. And clearly my colleague is right. When you use force, it can have unintended and terrible consequences. Just please notice that when you don't do anything at all, it also has terrible consequences. Let's get this thing balanced out. We're talking about tragedy here, whether you pick up the sword or whether you don't. And let's also remember that none of us pay the price for this. The people who pay the price are the civilians on the receiving end. So we have some obligations there. I was amused by the question about R2P always being in service of the powerful. It's an amusing point, but it has a slight unreality. We're sitting in Washington about a half a mile from the president most reluctant to use force in the modern period. There's absolutely zero chance, in my view, that the Americans will actually use military force here. So, and to pick up a point made by my colleague, one of the reasons that R2P is so unpopular in Washington is precisely as you describe it. They do not want to have intervention to be anything other than a discretionary exercise of power. They don't want it to be construed to be a perfect obligation. So let's be real about R2P in relation to the powerful. The powerful don't like it any more than the powerless. And Ken is making the point that the whole point of R2P was to provide better protection for the powerless and for victims. And if you then ask me in conclusion, as someone who was involved in the drafting of R2P, what I care about when I think about what a good world would look like, it's a world of responsible sovereigns. It's not a world subject to the invigilation of powerful states with, mass casualty weapons. It's a world of responsible sovereigns. What does a world of responsible sovereigns look like? Well, I'll tell you what it looks like. It looks like Venezuela this week. A bunch of Latin American states go to Venezuela and say, this thing is spiraling out of control. How can we help? What does a world of responsible sovereigns look like? It looks like Kenya, Tanzania, Zambia showing up, Ghana showing up on Kenya's door saying, you've just had election violence that could topple into the war of all against all. How can we help? I don't know whether any of them use the language of responsibility to protect. I don't care. What I like is the vision of a world in which responsible sovereigns perceive that they have obligations to other sovereigns, that sovereigns are not inviolable islands. The idea that intervention is only the business of rich white countries seems to me fatuously wrong. The 21st century, if we want responsibility, it will be responsibility of states looking after other states, engaged with other states, as the Latin Americans are at the moment with Venezuela, as the African states are with problems in Africa, African solutions for African problems, Latin American solutions for Latin American problems. That's where we want to go, and at the core of it, damn it, is a conception of responsible sovereignty. And that's why we wrote that report. And at the moment, we are a long way short of getting closer to that ideal. Thank you.
Okay, so Vera has warned us appropriately about the danger of sound bites, but nonetheless, I'm going to ask each of you to give a reasonably brief response to a final question. And Michael's comments anticipated the question with which I wanted to conclude. We continue to live in a world with many wildly irresponsible sovereigns. And I want to narrow the focus back to the theme of the conference and ask each of you, recognizing that there is a whole range of considerations and a whole range of axes on which we need to consider the question, I want to go back to international law and ask what development in international law would we look to in order to strengthen the effectiveness of international law in dealing with, and let's put it very bluntly, stopping, bringing to a halt the kinds of atrocities that we're all appalled by that are going on in Syria. And maybe I'll ask the question in reverse order from your preliminary remarks and start with On.
Of course, the best way to approach it, of course, would be to affect changes to the charter itself, to introduce new rules, but this has to be done by common agreement, and I think this is probably, it looks like a wild flight of fancy at the moment. There are, it's really very difficult, you know, people always expect that there is a solution to any problem, but there are some problems to which there are no solutions, and we have to recognize that this is the situation, at least in the foreseeable future. To just comment on responsible sovereigns, but that's exactly what I meant when I said that the countries of the region under Chapter 8 should take the lead. Maybe something that does not state formal changes in the Charter would be for the Security Council to refer more to regional organizations. I think, I really do, that have those organizations, I'm thinking more of the Islamic Conference organization rather than the Arab League, have they been permitted to play a greater role before the wounds deepened, before the tragedy became even more tragic, maybe we would not be in a situation like this. I think we can look here and there for agreements to do things like that, which do not necessitate formal change. But I don't think that the duty to protect, the obligation to protect concepts along those lines, I'm sure, which are motivated by the most noble intentions of the world, will be helpful in the situation of Syria. I would be very, attentive to see what my other colleagues say. Maybe there is something that I've completely overlooked.
Ken.
Well, let me just begin with Alan's point about regional organizations. We would love for the Arab League to take a leadership role here, I mean, contrast what the Arab League is doing in Syria, which is basically bupkis, with what the African Union is trying to do in Central African Republic, or Mali, I mean, Somalia, Central African Republic. These are tough situations, and the AU is deploying peacekeepers there. They're doing what they can. It's not always effective. It sometimes has to be supplemented by a UN peacekeeping force. But there's an effort there in every situation of mass atrocity on the African continent. Meanwhile, the Arab League has been looking at its navel for 3 years as the killing escalates and escalates in Syria. So, don't blame the Security Council for the lack of action, lack of regional solutions, the Chapter 8 stuff. I mean, it's there, take it, but nobody's doing it. So I think we have to be realistic here. The obstacle is not the Security Council. The obstacle is the Arab League. Now, in terms of what changes your question on, I think that there are international law is still at a rudimentary stage. We have imperfect enforcement mechanisms because of the veto, and so if you were a permanent member or a friend of the permanent member, you can get away with mass atrocities and for the most part avoid Security Council action, which creates an enormous gap in the enforcement possibilities. We have massive violations of international law and nothing is done. So I think what we need to do is to look at international law less as an excuse not to act, which is the way we tend to talk about the Security Council. God forbid we do something if one of the permanent members doesn't want us to. We have to instead look at the problem more as one of enforcement. There are serious violations of the law in significant areas involving massive loss of life. What are we going to do to enforce that law? And I think if we take that enforcement mentality, we can begin to make a difference, recognizing that the last answer is military force. But we should be looking much more readily for ways to establish tribunals, to enforce arms embargoes, to apply sanctions, to condemn. I mean, these are all useful enforcement tools, short of the controversial step of military action. But we can't feel that we've done our best once we've presented to the Security Council and it's done nothing. We've got to recognize that the responsibility to enforce is a broader one.
Michael.
Well, I feel in a slightly comic situation of having said my final word, and instead of repeating my final word, I'll just pass to my colleague.
Vera.
I agree entirely with Michael, which may seem strange on our R2P discussion, in the sense that you are seeing developments. You've referred to developments in Africa, to developments in Latin America, and that is precisely what I was saying, in the sense that settling, other regional actors coming in to settle things in a peaceful manner, and trying to cooperate. I mean, these are the basic principles of the UN Charter: cooperation, peaceful settlement of disputes. So I think that this is the kind of world we would like to see. Again, my nuancing statement is that R2P, I've only discussed this in the context of the use of unilateral military force. So if you want to call that R2P, fine. If you want to call it, meeting the purposes and principles of the Charter, that's fine with me as well. But this is exactly the kind of world we would like to see.
Just a very small comment. I wasn't thinking of the Arab League, but more of the Organization of Islamic States. And there, of course, Iran could have played a very important role, and that role was frustrated very early on in the Syrian crisis.
Look, I'll take the Organization of Islamic Conference. I'll take whoever you put forward, but nobody's acting, and that's the problem I have.
Like many of the discussions over the last week, this one could go a lot longer and be just as compelling. If you folks would join me in thanking Ken and Michael and Vera and Aaron. And on behalf of President Damrosch, Executive Director Anderson, President Wedgwood, Lord Nance, the program, on behalf of those folks and all of you, if I could take 1 second with Lori's permission to again thank a spectacular program committee and a spectacular group who organized it, Betsy and the folks from Tiller House, for this entire conference, which was a great treat. And then, Lori, maybe you want to come up and exhort people to come next year, or should we close? Okay. Thank you all. Hopefully you'll all be here next year.